into the studio with your host of Law Talk, attorney Steve Sabra.
Good afternoon. This is attorney Steven Sabra. You're listening to Law Talk on 1480 WSAR. We do this show every Tuesday from 1 to 2 p.m. It's your opportunity to call in with any law-related questions. Good afternoon.
Good morning. Is it good afternoon?
I think it is already.
Okay. It's hard to tell when you have cabin fever.
Yeah, no kidding.
I had a mishap, a slip and fall mishap recently, where it was a commercial structure, and I was on the sidewalk, and I had been walking in the road, and I noticed that the sidewalk seemed clear.
Okay.
And so I walked, across the front of the building, and rounded a corner, and I didn't notice that there was black ice, and that's what caused the slip and fall. What I did is I banged my head on brick ledge, a brick windowsill, and I had it cut. I had contusions. But I didn't go to a hospital, and I don't think I had a concussion. My question is, since I elected to walk on the sidewalk, thinking that the sidewalk had been cleared in good faith by the owner, I mean, is there a situation there, or
Well, the question I have is, was this sidewalk? I mean, it wasn't a public sidewalk. This is the sidewalk for this particular business.
Yeah, it was on his. I mean, it was his window ledge.
Okay, because it does get a little. In other words, sometimes a business will abut a public sidewalk. Yeah, and that gets a little trickier, and it's.
Well, it was it was South Main Street, so it is a public sidewalk technically.
Well, that makes it a little trickier. So, and I'm glad you brought that up because it is different, and the question becomes, let me put it this way: there are municipal ordinances that say that the abutting property owner has to clear the public sidewalk. So, but what the courts have said is that yes, those municipal ordinances are there, but they're there for the purpose of the city or town to basically assess a fine if the abutting property owner doesn't clear the sidewalk. If they don't clear the sidewalk and you fall on that public sidewalk, that doesn't mean that, however, that you can use the violation of that statute to say, well, that's evidence of negligence, then I have a claim against the abutting property owner.
What about good intent and the choice on the part of the pedestrian to walk on the sidewalk anyway, thinking that it's clear, which is a situation that would be unknown to the property owner up to a certain point, I guess,
Well, yeah, I mean,
and unknown to the pedestrian as well,
Well, and that gets to almost the next part of a case. So let's assume, let's make some assumptions. So let's assume that the reason there's black ice there is because there is either a gutter or some overhang that allows for the melting snow to fall on the sidewalk and freeze. Okay, so that condition then has been caused by the abutting property owner's property, whether it's the gutter that's directed on there or it's the awning that is allowing the snow to melt. When the sun hits it, snow melts, it falls. Okay, so in that situation, then I would say, well, then I'm okay with a case against the abutting commercial property owner because they've created this condition. But that's not the end of the issue, because the next part of it is, okay, that means there is a duty of care. Now, was the duty of care breached? Now, ultimately, that's would be up to a jury to decide, because a jury might feel, well, I wouldn't expect the property owner to be out there every 5 minutes putting down salt and sand. Also, it gets turned a little bit against the person that fell, because there's always this issue of, well, should you have seen it? Now, if it's black ice, people will say, I couldn't see it. It was black ice. It was impossible. Well, then it goes back to the property owner who says, well, yeah, you couldn't see it, and I couldn't see it either, and I was out there, this morning at 8:30. You fell at 11. I had put salt and sand out there. What more is required of me? So they're not easy slam dunk cases by any means. That's what
I'm saying. If I had $1,000 for every time I fell on the sidewalk in Fall River, I'd be a rich man by now.
Yeah, but, and nobody's going to pay you $1,000 every time you fell down on a sidewalk either, because it doesn't necessarily mean you actually have a claim against anybody.
Exactly.
That's what people don't realize.
I mean, the thing I didn't bother going to the hospital because it would have complicated matters for me getting back home even worse, know. And but and it's been a week since it happened, so I'm starting to heal. So it doesn't look as bad as it originally did. So, and I didn't photograph myself with a cell phone, or any of that.
Right.
Because I don't have a cell phone.
Well, then, that's
so there's really no proof, quote unquote,
Yeah, it makes it hard. I mean, most of.
I mean, some people would run home and document it right away, and.
Yeah.
It just didn't happen that way,
Yeah, well, and it makes it probably, if you came in and told me this story in the office, I am not sure that it would be worthwhile pursuing, because even though you seem to be a credible person, but let's face it, there's really no documentation that you actually fell there. In other words, normally what you would want someone to do, but people don't do this for a lot of very legitimate reasons, but if you fell on someone else's property and you got hurt significantly, it's important to notify the property owner.
Exactly. I mean, I was able to get up and get on my way. It wasn't, somebody had to come and cart me out of there.
Yeah. I mean, if an ambulance gets called, that's a different.
Then it's all a matter of record.
Exactly. So that makes a difference. So you probably handled it the right way. All right. Thank you. I appreciate the call. Okay. I guess that means we're going to take a short break. Again, my name is Attorney Steven Sabra. You're listening to Law Talk on 1480 WSAR.